Assalamualaikum warahmatullahi wabarakatuh and a very good day. I bid to Dr Hafiz. As an introduction to our topic of discussion, which is the Sharia advisory in any Islamic financial situation under the Governing Statute of Development and Financial Institution Act 2002, I will be explaining regarding the initial establishment of the Sharia advisory and also its development and last but not least, the current law that governs the Sharia advisory. For the initial establishment, the Sharia Committee or the Sharia Advisory Body were made pursuant to the statutory requirement enacted under Section 35B of the Islamic Banking Act 1983, Section 124, Subsection 7 of the Banking and Financial Institution Act, and also Section 16B of the Central Bank of Malaysia Act 2003, which is in use by the Bank Negara Malaysia for the establishment of its own Sharia Advisory Council. In Malaysia, the first ever advisory body concerning the application of Sharia in daily business was set up by the Bank Islam in 1983. Therefore, they have set up their own Sharia Advisory Council. It was then followed by numerous banks to provide Islamic banking schemes, and therefore, each bank or even Islamic financial institution enacted their own Sharia committee or Sharia advisory body to advise them regarding Islamic products. Therefore, in order for the interpretation of the Sharia rulings regarding the banking and finance to be made harmonized and consistent, the Bank Negara Malaysia established a National Sharia Advisory Council in 1997. This is to regulate the Sharia authority regarding the numbers of Sharia advisory under the respective banks and institutions. So the developments of the Sharia Advisory Council, we can see that in the case of Arab Malaysian Finance Berhad against Taman Ihsan Jaya Sdn Berhad, the court held that there is no necessity to refer to the Council of BNM for any rulings, but it can be taken into consideration with no binding effects on the court. It was done in the case of Bank Islam Malaysia Berhad against Lim Kok Ho, where the Court of Appeal held that when a bank's business is in accordance with Islam, the court will need to consider jurists who are qualified in the Islamic jurisprudence. Last but not least, regarding the current law that governs the Sharia Advisory Council, we can see that some of the laws that governs the Sharia Advisory are the Development and Financial Institution Act 2002, which we will discuss primarily in this topic, and also the Central Bank of Malaysia Act 2003, and lastly, Islamic Financial Services Act 2013.
Bismillahirrahmanirrahim. Now we will move on to the main structure of the SAC. Now firstly, the composition of SAC is that it consists of pronounced scholars, lawyers, professional that is very pertinent with the Islamic economics and financial experiences. Now these scholars will act as advisor to the Bank Negara Malaysia and also all the other Islamic financial institutions. Now the SACs in Section 33F of the Development of Financial Institution Act, the FIA, prescribe that an institution of Sharia Compliance Committee shall be established in which will be regulated by none other than these eminent scholars. Moreover, the SAC is an independent authoritative body. It is established under Section 51, Subsection 1 and Subsection 2 of the CBMA, the Central Bank of Malaysia Act, which confers them jurisdiction as to be the sole governing body responsible for matters relating to Sharia compliance within the Islamic banking and finance environment. To establish a strong foundation of regulatory body, the SAC is free from any conflict, even when it is established under the Bank Negara Malaysia. And lastly, the SAC has its own decision-making capacity, in which was made pursuant to consensus of its members, or in some circumstances, through majority vote. Now, this decision will then later be used as guidance for Bank Negara Malaysia and all other Islamic financial institutions as binding rules. Moving on to the qualification of the SAC, Section 51, Subsection 1 and Subsection 2 of the CBMA provides that SAC was established by Bank Negara Malaysia, and it shall have its own determination of procedures in which confers powers on the SAC to be a qualified advisory body. Now, Section 56, Subsection 1, 57 and 58 of the same Act collectively describe that rulings of the SAC can be regarded as binding upon any court of law, arbitrators, Bank Negara Malaysia or any other Islamic financial institution. And on the perspective of DFIA, Development Financial Institution Act, Section 33D also provides as the same as Section 51, aforementioned on its jurisdiction, as well as 33E on its ruling as aforementioned in CBMA previously, as to be effective and binding.
Now we proceed to the procedures of appointing Sharia Advisory Council. In general, as stated under Section 31 of Islamic Financial Services Act, it outlines requirements for prior written approval from the Central Bank of Malaysia for appointment or acceptance of appointment of SAC. As outlined under Section 33G of the DFIA, it stated that no individual can be appointed or accept an appointment as a member of Sharia Committee unless they fulfill the specific requirement specified by the bank and obtain prior written approval. However, it does not specify in detail the procedures needed to be followed. The specific procedures for appointing Sharia Committee members in Islamic banks and takaful companies can be seen outlined in the Sharia Governance Framework. The appointment and the reappointment procedures can be seen described in the paragraph 2.3, paragraph 3.8, and appendix 2 of the Sharia governance framework, where it involves several steps. First, the procedures of appointment begin with the institution conducting a vetting process to ensure that the proposed individual is qualified and suitable for the position. Then, the institution's nomination committee screens the candidate and recommends them to the board of directors if they meet the requirement. Next, the board of directors, upon the recommendation of the nomination committee, nominates the proposed person to Central Bank of Malaysia. The final decision of the nomination lies within the board of directors. It should also be noted that the application for the appointment must be submitted to Central Bank of Malaysia at least 60 days before the proposed date of appointment, using a specific form provided in the Sharia Governance Framework. Central Bank of Malaysia and the Sharia Advisory Council review the application and provide their written approval. Central Bank of Malaysia also impose additional conditions if they deem necessary. Now we proceed to the duties of the Sharia Advisory Council. The duties of the SCC in Malaysia, as specified in Section 52, Clause 1 of the CBMA, include a number of important duties, one of which is the need to determine the applicable provisions of Islamic law in any financial problem and to issue judgment in response. Second, the SSC advised Bank Negara Malaysia on matters of Sharia pertaining to Islamic financial activity as well as the operations and dealings of the bank. Thirdly, in accordance with the written law, the SAC provides direction and assistance to Islamic financial institutions and conventional banks that have Islamic products. Section 55 Clause 1 and 55 Clause 2 of CBMA outline that Bank Negara Malaysia and Islamic financial institution needs to be consulted by the Sharia Advisory Council before making any decision in matters pertaining to Islamic banking and financial businesses pursuant to Section 55 Clause 1 and 55 Clause 2 of CBMA. This means that when an Islamic financial institution requires Sharia advisory services, they engage with the Sharia Advisory Council. Additionally, Section 56 Clause 1 states that in matters relating to Islamic financial business or question regarding Sharia, courts or arbitrators should consider any published ruling of the SAC or refer such question to the SAC for a ruling. In the perspective of DFIA 2002, the Section 33D illustrates that institution must ensure that its business affairs and activities are in compliance with Sharia principles. Moving ahead, Section 33E allows Bank Negara Malaysia to determine standards pertaining to Sharia matters by giving effect to any recommendations or decision made by the Sharia Advisory Council. The board of directors, senior officials, and members of the Sharia committee are in charge of creating Sharia compliance rules and ensuring that Sharia principles are followed as stated in subsection 2 of the Act.
Greetings and hi everyone. I will explain the roles of Sharia advisory in regulating Islamic banking and finance products. So, Sharia Advisory Council is responsible for first, supervise and oversees Sharia products and finance services provided by the financial institutions. In this context, the Sharia Advisory Council is entrusted with the responsibility of overseeing the development, implementation, and supervision of Sharia compliant products and services. By providing guidance, conducting audits, and monitoring compliance, the Sharia Advisory Council plays a crucial role in maintaining the integrity and authenticity of Islamic banking and finance, safeguarding the interests of both institutions and customers, like under the governing statute of the Development Financial Institution Act 2002. Second, provide guidelines and advice for Sharia legal standard. These guidelines refer to the product's characteristic and structure to ensure adherence to Sharia standards. The contracts, conditions, and requirements of the products must all be reviewed and approved. Third, Sharia Advisory Council is responsible to safeguard and conduct continuous auditing in all Sharia-related finance institutions.
Next, we'll discuss regarding the strength of the DFIA 2002 in regulating the Sharia advisory. Part 3A of the DFIA now includes Sharia requirements in order to be in line with the IFSA 2013. And not only that, the DFIA imposes that the failure to comply with certain sections as an offense. Thus, it shows that the DFIA is effective in regulating the Sharia advisory. First and foremost, the DFIA 2002 upholds the Sharia principle sanctity by imposing penalty on the non-compliance of any Sharia rulings. This can be seen under Division 2 of Part 3A, where any institution that fails to uphold the Sharia is in violation of the DFIA, and if convicted and found guilty, the offence is punishable by a maximum of 8 years in prison, a maximum fine of 25 million ringgit, or even both if convicted. Next is that the DFIA 2002 ensures only qualified person chosen as the member of SAC. Section 33G of the DFIA shows that although the financial institutions can establish its own SAC, the appointment, reappointment, and also termination of any person as the committee must obtain the written approval of the BNM. This is vital that the person comprising the committee is a qualified person with extensive knowledge of the Sharia. Last but not least, the strength of the DFIA 2002 is that it includes auditor for checking on the SAC. Section 33M provides that the Sharia compliance by the Islamic financial institutions to be audited after appointing any person approved by the BNM, and the auditor is responsible to submit a report to the BNM on the audit that was done on the institution. Therefore, this shows that the FIA is functional to regulate the SEC, as they will be audited on matters inclusive of their advice and rulings, as the results of the audit will be submitted to the BNM. Therefore, based on these three examples given, the strength of the DFIA in regulating Sharia Advisory Council is proven.
Good day, my name is Zaki Zaid and I will be presenting on the challenges faced by the FIA 2002 in regulating Sharia advisory. My first point will be on the SSC made by private bank can only make recommendation will not constructively binding upon private banks and financial institution, hence may creating a lack of compliance by this banking and financial institution presented in their products. Secondly, the FIA does not provide standard norms or rules for member criteria on who is eligible as member of SAC thus lead to varying level of knowledge and inconsistency among the members' decision. Thirdly, the FIA not be able to cope with fast-changing developments in Islamic finance system that involve complex and ever-changing jurisdictional and structural changes across different regions and countries. Moving on to the next slide, a standard and uniform guidelines that applicable across different financial institutions whom conduct different financial undertaking may be modeled by BNM, which can result on inconsistency between different governing statute that regulates as AC institutions.
In conclusion, Development Financial Institution Act 2002 and other statutes provide a solid foundation for Sharia advisory mechanism in Malaysia, with more improvements that can be made from time to time. Besides, the improvement can be made in the context of its efficiency, guidelines, flexibility, and other relevant matters that can be addressed by policymakers in order to increase the effectiveness of Sharia advisory frameworks in Malaysia. That's all from our group. Thank you, everyone.